Welcome. So, you've seen several of the discussions that we've had on the vitiating factors, those circumstances or factors that allow contracts to be set aside. Prior to this, you might have watched also the discussions that we had on duress. Here we are going to focus on the subject of what we refer to as undue influence. Undue influence. Now, you remember that when we spoke about duress, it was a matter that was appreciated that in contract or binding agreements, parties ought to be free to bind themselves to terms that they believe is in their best interest. That freedom ought not to be interfered with. So if Kwame and Kofi have what we call a contract, we believe that Kwame freely got himself into the contract. Likewise, Kwame or Kofi also got himself freely into the contract with the parties. There shouldn't be any kind of situation where the persons found themselves into the agreement or were bound into the agreement beyond anything that they by themselves would have wanted to. So we saw how duress catered for that. Under the subject of undue influence, we are looking at another situation where the courts allow a party to set aside contracts that he has gotten into with another person, or allow one party to set aside a contract because from the entire assessment of the way the contract was construed and how the contract was formed, you realize that one or more of the parties were disadvantaged. And that disadvantage operated in allowing the person to find himself in the contract against his will. So that setback, that greater view, or that insight into the entire circumstances under which a contract was formed, and seeing that the parties didn't freely contract, is what the courts always try to ascribe to the rule we call an undue influence. So essentially, in undue influence, we are saying that one of the parties was not free or did not freely exercise his will in the contract. And this is not because you can particularly see a force as it is present in duress, but upon the examination of the entire contract, you can see that on equitable grounds, this was not a situation where the parties freely contracted. We refer to that as the doctrine of undue influence. How does it operate? Now, essentially, there are two legs of the doctrine of undue influence. One of them is where we have the actual or express undue influence, and the other is where there is a presumption of undue influence. So, the actual or the express undue influence or the presumption of undue influence. What do they actually mean? Okay, so let's see the first one, actual or express undue influence. What is it in actual undue influence? Let me relate to you one very fine common law case. The case was Molly versus Lawman. Now, Lawman was a man who belonged to a certain religious group, a religious sect. He didn't have so much money. He was a man of little means. Some way, somehow, he got in contact with Molly, who was a rich guy. He held a huge fortune, but he was epileptic, which means that he had some neural problems. Okay. In the course of association of Molly and Lawman, Lawman was able to get Molly to now buy into his religious views of things. So over time, Molly now moved into Lawman's facility. He lived with him, and he kind of practically was the one who was guiding Molly throughout most of his things. Now, when Molly died, there was a will or a gift that he purportedly had made to Lawman, which was in some substantial amounts. I think about £140,000 or so. So the executors of Molly's will said that no, they want to recover that money that is in Lawman's custody from him, because he kind of unduly influenced Molly, this epileptic person, to kind of give him that kind of amount. You understand that? So you will see that the grounds that they were now fronting was that there was an actual pressure, a certain coercion of will, not that the person used threats, but a kind of influence that was so overbearing on the fellow that he he had no option to exercise an independent mind of his own. This is what we refer to as an actual undue influence. Now, Dr. Christine Douna Hammond, one of Ghana's prolific writers on the law of contract, in the invaluable book, The Law of Contract in Ghana, made a commentary on this Molly versus Laumann case. Let's see what Christine Douna Hammond said in The Law of Contracts. By Douna, where it can be shown that one party exercised such domination over the mind and the will of the other party that his consent to a contract cannot be said to have been independently given, the party who was so dominated can rescind the contract on grounds of undue. So where there is a domination of the mind of one of the parties, so substantial to the extent that you can look from the circumstances and say that no, this person didn't really freely or had an independent mind in the way he took the decision to enter into the contract. The law is that when that happens, the contract can be rescinded on the grounds of what? Undue influence, which is there was an overbearing, a disproportionate amount of pressure that came upon one of the weaker parties such that he couldn't have freely understood or consented to the terms of the contract. That is what we refer to as undue influence. In another common law case, which we call Alcott versus Skinner, this is what the law justices also said, Lindley L.J., when he mentioned on the subject of undue influence. Alcott versus Skinner. Some unfair and improper conduct, some coercion from outside, some overreaching, some form of cheating, and generally, though not always, some personal advantage obtained by the guilty party. You saw in Alcott versus Skinner, Lindley J's fine statements. So some overreaching, some kind of domination, some kind of cheating that allows the guilty party to obtain that advantage, and some coercion that draws the person inside. And you saw the point that mostly this coercion is a bit covert, it's not so obvious, but you realize that it has got this kind of subtle overbearing pressure, something akin to that. The court says that it will be a grounds of undue influence. So clearly, when we talk about undue influence, that is what we mean. It's more of an exploitation of the weaknesses of one of the parties, okay, to such an extent that you can see that this person didn't have the ability to exercise free will because he didn't have an independent mind of his own, okay? So in the Molly versus Laumann case, for example, the court held that that gift, that purported gift that Molly had given to Laumann had to be properly revoked because there was what we call the existence or an actual undue influence, all right? And note that the burden is always on the party who alleges the actual undue influence to prove it. So if there is a contract between two parties, okay, and one party now decides to rescind the contract on the grounds that there was undue influence that came to bear over him, evidence has to be led to be able to support that position that truly he was deprived from the power of exercise of free will by the existence of an undue influence operating on him. So this will work in gifts. It could also work in situations where you are dealing with the estates of deceased persons. In one very recent Supreme Law case, it's Michael Senti versus Reverend Father Monkwame and another. I mean, a very famous case, the Senti case. Mr. Senti, the late Senti, was a very rich man who lived in Sunyani. Then when he died, according to the will that was read, all his properties, he gave it to one of her daughters. All his properties. Though he had a son, the boy didn't get anything out of it. Now, when you look at, according to Michael Senti, who was a son of Mr. Senti, he said that the distribution of the property, the way it was given out, everything like that, it was inconsistent of his father's attitude. So he took the matter to court and sued the executors of his father's estate, that's Reverend Father Monkwame and another person, seeking to set aside the will and this content, that the will should not be admitted to probate because his father was unduly influenced in the execution of the will. So the burden was therefore upon him that if you now want to set aside the will, you therefore need to establish on what grounds are you saying that there was undue influence that was brought to bear. That's what we're trying to say. obviously or eventually, Michael Sainty, per the available records or the facts that he had used before the court, was not able to establish sufficient proof that his father was unduly influenced in the manner in which he disposed of or his property. Okay, he disposed of his property. So clearly, the Supreme Court now decided to now set aside and said that the will had to be admitted to probate, and the contents of his father's will were also equally admitted. So that's the point. We are saying that where there is actual undue influence, all right, as we have established by the authorities, the contract can be rescinded. And when the contract is rescinded, we know what happens. The parties are free to go, and any obligations that arises thereof cannot be further performed. Okay, so having looked at the subject of, having finished the component of the actual undue influence, let's look at the other leg of undue influence, which we call the presumed undue influence. Okay, so the presumed undue influence or the presumption of undue influence, what do we mean? You see, there are certain kind of special relationships between certain parties. The law calls those kind of relationships fiduciary relations. I'm sure you've heard of that. If it's your first time, this is what fiduciary relations are. Hello. Thank you all for the appreciation and warm commendations for the videos that you keep watching and enjoy. We are proud and always excited to be there to serve you with much more educated videos. If you have any trouble, either in your study of the law or any other matter, feel free to reach us 0540 550 541. Fiduciary relations are simply relations between two parties where they undertake to treat each other with utmost good faith and trust. Okay? That is, because of that special relationship between the two parties, it becomes a necessary term or a necessary component of the relationship that all matters should be dealt with in good faith, in good trust, and in truth. Examples of fiduciary relations will include a lawyer and his client. If a client goes to a lawyer, the understanding is that the lawyer is supposed to be truthful, he's supposed to conduct matters in a manner that shows that he is putting the interest of his client at heart. A physician or a doctor and a patient, okay, that is also a ground of we saying that it's a fiduciary relation, or some kind of other kind of contractual situations where the general principles of good faith operate. Therefore, the law is that when there is a contract between these two parties, a lawyer makes a contract with his client, a doctor has a certain contract or binding agreement, a supposed binding agreement with his patient, the law presumes that the patient is in a disadvantaged position, the client is in a disadvantaged position. So there is a presumption that the interest of the lawyer superseded that of the client. There is a presumption that the interest of the doctor superseded that of the patient. You understand that? So the law presumes that the weaker party was unduly influenced. Therefore, if that contract has to be sustained, the stronger party, i.e. the doctor, i.e. the lawyer, needs to lead evidence to show that that undue influence was absent. How would he be able to justify that? He'll be able to justify by being able to demonstrate that maybe there was sufficient opportunity for the person to have independent advice. So if it was a case of a lawyer, did the lawyer allow the client to think over the suggestions that he had given him so that he could return in the affirmative that he agrees with it? If it were a patient and he had an agreement with a doctor on some kind of contract, did the doctor allow the patient sufficient time or maybe consult with another person so that he accepts to the terms that he's given him? That is what it means to be able to now justify that. Though there is a presumption of undue influence, it did not operate on you. In law, we call that a rebuttable presumption, which means that you can lead evidence or give us further statements or facts to disprove that that kind of relationship affected the terms of the contract. Are we fine? So the law is, and we state it again, that you can have undue influence arising by the operation or the understanding of the law when you have these kind of special relationships. Okay, so doctor-patient. It could even be, the law has also admitted the case of a religious leader. Okay, a religious leader who has a following. You know, today in Ghana we have several people that they are following, pastors, a man of God, who are giving them ideas as to how things have to be done. All right, that is fine. So that kind of special relationship, all right, that religious leader-follower relationship, it creates a presumption of undue influence. So the law is that when any contract arises out of that, we presume that the stronger party overbeared on the weaker party, unless evidence is brought, as I have indicated, to show that that wasn't the case. The person was entitled to an independent opinion. He was given sufficient opportunity to consider all the facts and decide, and he eventually accepted to that. So that is what we mean. Okay. In one very powerful Supreme Law case, Supreme Court of Ghana case that was held, CSC Construction and Rita Reed versus Ransom Divine Atisogbe. I'm sure you've heard that case. I mean, it was delivered, and the judgment was written by one of Ghana's finest justices, Professor Samuel Kofi Datiba, Justice of the Supreme Court, as he then was. This was a case where you had an 80-year-old woman, okay, who had now brought this young man into his fold, into his business, as someone that he trusted. Okay, now some way, somehow, the young man was able to get the woman to transfer a certain percentage of the shares that she had in the company to him. Okay, though he had made him a director. The guy did so many things that, I mean, the woman said that she did not agree. So it was a kind of an assumption, or you could see that he was taking advantage of the woman. Okay, because the woman was 80 years old. So what is that? What is that? You clearly recognize that. Then there is a presumption of what? Undue influence. The reason is that you have a relationship that has resulted based on trust. Okay, the people came into that based on trust. So there was a kind of a fiduciary relation that had now been established, a relationship of confidence between the two parties. And that relationship of confidence, as we are saying by the law, it also occasions what we call a presumption of undue influence. So you have to allow the burden is on the person who now wants to hold the contract as being correct, to be able to prove that truly he didn't take advantage of the weaker party. Now, that is essentially what we mean by presumed or the presumption of undue influence. That now transitions us into another important aspect and the final part of our discussion of undue influence. That is what we refer to as unconscionability of contracts. Okay, so unconscionability of contracts. What do we therefore mean by unconscionability of contracts? So, guys, you've seen from the discussion we've had so far that a person's capacity or a person's right to exercise his free will in binding himself up to a contract cannot and ought not to be interfered with. If it is directly interfered with, as you saw in the video on duress, it's enough grounds for us to set aside the contract. If, however, there seems to be a subtle, an indirect, an outside pressure that is brought to bear on the fellow, either it was actually done or because of the unique circumstances in which they found themselves in, the party was led to get himself involved in the contract, we say that the contract could be set aside on grounds of undue influence. But what then do we mean on unconscionability? Unconscionability has got traits of all these subjects of undue influence. What unconscionability simply suggests is that the terms of the contract and the way the contract was drafted or the obligations created in the contract on the parties were so onerous, were so unreasonable, were so offensive to the senses of or consciences of reasonable people. Do you understand that? That's essentially what we mean by unconscionability. So the courts are now going to look at it and say that no, this kind of contract, if you look at the terms, no reasonable person should be able to enter into those terms. And the court arrives at that because there is existence of a certain disadvantage or disability in one of the parties. And it is apparent to the court that that disadvantage was exploited. That disadvantage of the party was exploited. And it's upon the exploitation of that disadvantage that allowed the stronger party to also benefit from the contracts that he intended. That the court will now set aside the contract as being unconscionable. Do you get that? That's what unconscionability does. So the difference between unconscionability and undue influence, as has also been reiterated in the case of the CSC construction versus Atisobe, just that the part said that undue influence is more of a focus on the situation of the weaker party. Unconscionability, therefore, seems to be more of a focus on the actions of the dominant party or the stronger party. So the way the stronger person does his affairs, to the detriment of the weaker party, the court will be able to set aside the contract as being unconscionable. Unconscionable to mean that it is offensive to good conscience, it is offensive to the morale and the ethics of rational thinking people, and the court will not allow that to stand in exercise of the court's inherent jurisdiction in equity. So, for example, what are some of these disadvantages that the courts have held to be a situation where it could be grounds for a contract to be set aside as being unconscionable? Then the kind of disadvantages where it is exploited and the matter comes to court and the court sees that it has occasioned what we call a miscarriage of justice, the court will now set aside the contract. This may include literacy, okay? It may include sickness, it may include old age, it may include poverty, it may include lack of assistance and all that. When those things operate on a person, said that it disadvantages him, and someone binds him into or purports to bind him into a contract, when the court looks at it and realizes that that contract is offensive to good conscience, we will set it aside. It happened in the case of the CFC construction, as we mentioned in the Atisogbe case. It's the same. This was a young, seasoned, right-thinking, rational human being who was able to get an 80-year-old woman who was even barely able to appreciate the mechanics of company operations and all that to transfer a substantial interest in her shares to him. How was he going to be able to justify that particular claim? So obviously, the position of the court was that there was an exploitation of the weaknesses of the old lady. That exploitation was made apparent because Atisogbe did not allow the woman an opportunity to independently think through and verify, perhaps even confer with someone else and see whether the decision that she was taking was true. The point is, if in law such an action comes before the court will render such a contract as unconscionable. One famous Gold Coast case that also comes to mind is the case of Kwame versus Kufuor. This was where in the Gold Coast era, a prospector had gone to engage in a contract with some villagers. And in the village, when he went to the contract with the villagers, he said that he was going to give them, I think, £500 or so. And that £500 for a certain duration, that was not going to be ever reviewed for all the period that he would be excavating gold from the site. Think about it. So the Gold Coasters accepted to it. Then one of their royals, or one of the children from the royal family, got up upon and said, no, this contract that we had with our grandfathers, and it's not a contract that I can allow you to stand. So the matter went to court, and the court looked at it. And the court looked at the balance. This is a Gold Coast prospector, someone who has got serious commercial acumen. He understands the business. You go and you meet old people who are in the village with the greatest of respect, and they don't really understand the commercial effect of gold prospecting. Then you tell them that you're going to give them a fixed paltry sum that will not be negotiated or that is not subject to an increment or review over a considerable period of time, whilst you just keep on digging your gold. Abba, doesn't gold appreciate? Gold appreciates. So how come that your rise to the prospect and the digging of gold cannot also be subject to review? So the court looked at it, observed the weaknesses of the literacy of the people, looked at it and said that no, such kind of contract was unconscionable, and the court had proper grounds to set it aside as such. So when we say unconscionable contract, guys, that is what we mean. We're okay? All right, so in this discussion, we've seen what we mean by undue influence. Again, we are saying that it is a kind of influence, okay, that is usually brought from the outside on the parties. It operates that in such a manner that because of the special relationship that the parties may have, okay, one party, it seemed to be disadvantaged in that manner. And we saw those kind of fiduciary relations. We've also seen that you could also have some of the contracts being also set aside or struck out as being unconscionable by the courts. And unconscionable, we have said that it is offensive to good conscience of reasonable people, that such a contract should be allowed to stand. The court has an inherent jurisdiction to inequity to make sure that justice is done to all parties who intend to freely enter into contract. Said that their inherent weaknesses, their natural troubles that have no fault of theirs, does not substantially disadvantage them when they come into agreements with people. So essentially, this is what the doctrine of undue influence has to say, and it allows the party who now is disadvantaged to set aside the contract as such. Remember, he will carry the burden to be able to prove whether or not the contract, he was unduly influenced in that.